At the top of the U.S. federal court system sits the United States Supreme Court. Based on Article 3 of the Constitution, the Supreme Court is identified as the highest court in the land and has the final say in any legal matter that reaches the court. The United States Supreme Court exists to fulfill three essential purposes within the American government, the American legal system, and the Constitution of the United States. The first purpose is to ensure that your rights as a citizen that are outlined in the Constitution are being respected and recognized by both private citizens and the government of the United States or of any one of the 50 states. The court also exists to ensure that government actions are being taken within the rules and boundaries established by the Constitution. This can include things such as the separation of powers between state and federal government, and it can review instances where an action of government may or may not have violated the rights of citizens. Lastly, the Supreme Court exists to review and decide the most important legal matters and make decisions on those cases so that our country can operate. If a case reaches the Supreme Court, it likely has a major constitutional issue or question that needs to be answered, or involves a situation where the checks and balances or correct operation of our government and legal system has not occurred correctly. The Supreme Court and its powers come largely from Article 3, Section 1 of the Constitution, which says the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. This statement creates the federal court system with the Supreme Court at the top and gives it the authority to hear and overrule the decisions in cases of courts beneath it in the federal court system. One of the most important cases related to the power of the Supreme Court is the case of Marbury versus Madison that occurred in 1803. In this case, there was a dispute involving a man named William Marbury, who had been appointed to be a federal judge under a law called the Judiciary Act of 1789. Marbury was appointed by John Adams, but before his commission, the legal document that gave him his position and power as a judge was delivered to him, John Adams left the White House as president and was replaced by Thomas Jefferson. Jefferson ordered James Madison, who was working in his administration, not to give Marbury his commission and thus prevent him from becoming a federal judge. Marbury sued James Madison and Thomas Jefferson, taking them to court, saying that he was entitled to become a judge, even though his commission had not been delivered. He believed that since John Adams was president and had the power to appoint judges, and had appointed him to be a judge, that was sufficient for him to be given the position. When the Supreme Court reviewed the case, they ultimately decided that Marbury was not entitled to his position because the section of the Judiciary Act that was used to appoint him was actually a violation of the Constitution, and thus the law was illegal and Marbury's position would not have been legal. This case is essential in American legal history because it established two major things. It established that the Supreme Court had the final say in any legal decision or government action, and it established the court's power of judicial review, that its authority within the Constitution and its job is to review the actions and laws of government in the United States and overturn them or reverse them if they are in conflict with the Constitution of the United States. The Supreme Court is structured with 9 justices who ultimately hold its power and exercise its power through their decisions. The most important justice on the court is known as the Chief Justice. This is currently being filled by Judge John Roberts, And the Chief Justice has two important roles. The first role is to organize the court when it is in conference and direct that activity, which will be reviewed later in this presentation. And the judge usually speaks first when the court is convened to hear cases or to meet in conference. The Chief Justice does not have any extra authority on the court, and the Chief Justice does not have any more or less power in their vote. They are simply one of the 9 judges on the court, but they are given the responsibility of organizing and managing the court's day-to-day activities. The Chief Justice is also used to identify the different eras of the Supreme Court and its history. Since John Roberts is currently the Chief Justice, this era will be classified as the Roberts Court, and all of the decisions associated with it will be identified as being decisions under John Roberts' leadership. In addition to the Chief Justice, there are 8 associate justices who serve on the court. Each of these justices, along with the Chief Justice, has the role of hearing and reviewing the cases that are brought before them, and ultimately voting on whether a case should be reviewed by the court, whether a case was decided correctly, or whether there was a violation of constitutional law, and then ultimately expressing that opinion when the court issues its ruling. These 9 judges, as a result of their power, are 9 of the most powerful people in the United States, as you will see when we talk about the decisions they can issue. The Supreme Court is unique in the United States, that it is the only court that has 2 types of jurisdiction. The majority of the Supreme Court's jurisdiction comes in the form of appellate jurisdiction, where the Supreme Court can hear an appeal of a case from a lower court. When this happens, the Supreme Court can look at one of 2 factors. They can look at procedural issues, such as was a law executed properly? Did a government official abuse their power when they acted on a law? This would be things such as how police treat suspects in an arrest situation, whether police have read a suspect their rights, or whether a warrant was properly executed to search someone's property. All of those would be procedural issues dealing with how the law was executed by the people responsible for executing it. The second thing the Supreme Court can look at in an appeals situation is what we call substantive jurisdiction. In this case, the Supreme Court is looking at the actual purpose of the law being challenged to decide whether it violates the Constitution. Since we have the 13th Amendment outlawing slavery and the 15th Amendment granting African Americans the right to vote, if a state tried to institute a new law about slavery or restricting the right to vote to African Americans, that would be a substantive violation of the Constitution. The law that they wrote and what it was designed to do violated something in the Constitution, and that gave the Supreme Court the authority to review it and ultimately overrule it. In addition to appellate jurisdiction, the Supreme Court also has original jurisdiction. While this is rarely used, it allows the Supreme Court to be the first court to hear a case. In any instance where multiple states would be suing each other in a civil matter or have a legal issue between the 2 states, the Supreme Court has the authority to hear that case, and they are the only court to hear that case. In other rare instances, the Supreme Court can actually choose to bypass the appeals courts in the state and federal court system and hear a case directly. This rarely occurs, but in instances of national emergency or time-sensitive scenarios, the court could take this power on and be the first court and only court to hear a case. In order for a case to reach the court, 4 of the judges must review the case and believed that there was a constitutional issue worth reviewing. This process is called the Rule of Four and is used to determine whether any case gets to the Supreme Court. As you learned about in previous video lectures, most cases do not reach the Supreme Court. Citizens can appeal and ask the Supreme Court to review their case, but it rarely happens. Due to the time constraints and the limits on the Supreme Court's power and time, they are forced to hand select cases based on the details of them. And they use the Rule of Four to narrow down the list of cases that are requested for them to hear to the actual cases they are able to hear in a given year. Once the Rule of Four has been established and 4 judges agree to review a case, the Supreme Court issues a document known as a writ of certiorari. This document orders a lower court to send them the information and all of the legal records and documents about the case they want to hear, and this is how the majority of cases reach the court. A petitioner asks the Supreme Court to review, they use the Rule of Four, and then they direct the court who had previously heard the case to send them all of the information. In other instances, the Supreme Court can have a case brought to them through what is called a certificate. In this scenario, the judge in a lower court asks the Supreme Court to review a procedure or issue in a case because the judge is not sure how to resolve the case. This is usually done to make sure that a case does not need to be appealed to the Supreme Court after its decision in a lower court. The judge seeks out clarification from the Supreme Court, and they issue a ruling so that the lower court judge can properly make the decisions and take the actions necessary in the case in front of them. Once a case reaches a court, the Supreme Court, there are 2 ways it can be presented. Most cases are heard through briefs, which are written documents prepared by lawyers and that are sent to the court to be read and reviewed. In these documents, the lawyers detail all of the arguments that they would make in front of the court, explaining why they feel a lower court's decision was wrong or why a situation violates their client's constitutional rights and why the court should reverse the decision, or why the court should uphold the decision and why the lawyers feel it was the correct decision. In a few unique instances, the Supreme Court also grants what are known as oral arguments. In these cases, lawyers prepare and submit briefs, just like in previous cases. However, in these cases, lawyers are given 30 minutes to actually argue their case in front of the 9 justices on the Supreme Court. In these scenarios, the judges are able to ask questions of the lawyers and challenge the arguments that they are making in their briefs so that they can get more clarification about the situation and the case's history in the lower courts. Usually, oral arguments in cases are heard in 2-week cycles where the court will sit to hear cases, read briefs, and listen to the arguments presented by the parties involved, and then the court goes about reviewing those documents and ultimately discussing those cases in conference, as we'll talk about in the next slide. Once a case has been argued in front of the Supreme Court, the 9 judges review the documents and transcripts from the case and meet in what is known as conference. In this situation, the 9 judges meet in private to discuss the cases that they have heard and read through the oral arguments and briefs. In a conference session, the judges each present their opinion to the other 8 justices on the court and explain how they think the case should be resolved. This process usually begins with the Chief Justice going first and then continues through the 9 judges in order of seniority, with the most tenured judge going first and the least tenured judge issuing their opinion last. Once all 9 judges have issued their opinions in conference, they take a vote on the case and ultimately author one of 3 potential opinions that they will issue regarding the case and its outcome. Once the judges have met in conference and voted on the outcome of a case, they go about the process of writing and releasing one of 3 opinions. These opinions are usually released in the late spring and early summer of a year, and the Supreme Court, through these opinions, gives us the resolutions to the cases they have reviewed that year. Every case that goes before the court will be receiving a majority opinion. This opinion explains the reasoning that the majority of the justices used to decide the case, and ultimately what the outcome of the case is. If they are overturning a lower court's decision, they will explain that and explain why. If they are upholding a lower court's decision, they will explain why the decision was correct and why it will not be overturned. The majority opinion in many cases will become a precedent for future cases, meaning any similar case that comes before the court on this type of issue will be decided in a manner similar to the original case. You will see examples of this as we talk about cases in the coming week. In addition to the majority opinion, judges can issue a concurring opinion, which is where a judge who agrees with the outcome of the case wants to highlight a different legal reason or a different factor in the case that they used to make their decision. This opinion is written by a member of the majority because they are agreeing with what the majority of the judges felt was the proper outcome, but highlights a different aspect of the case. This opinion does not become precedent in future cases and does not actually become the law on this issue, but can be used as part of the discussion in future cases related to that topic or issue. Lastly, the judges in the minority will issue a dissenting opinion. In every case, at least 5 of the judges have agreed that they will have a particular outcome, either overturning the lower court's decision or government action, or upholding it. If the 4 judges in the minority, or 3 or 2, or 1 judge in the minority, depending on the outcome of the case, decides they want to issue a dissenting opinion, they have the ability to write a document which outlines why they disagree with the Supreme Court's decision. It also outlines their legal reasoning behind making the decision. Again, dissenting opinions do not have any legal weight. They do not have any influence on what the law in the United States will be, but they are things that can be argued and presented in future cases where you have similar legal issues being discussed. In total, the Supreme Court exists to make sure the legal process in the United States is conducted correctly, to make sure the rights of citizens are recognized and respected, and to hold government accountable when it takes actions that violate the rights of U.S. citizens. This power and ability gives the Supreme Court a significant amount of influence over the lives of American citizens and over the powers that government has, and we will be examining examples of this throughout the remainder of the year.